interaction with the bill. It will take a bit of time. You are all welcome, and special welcome to Professor Msimang, who has joined us today. We know that you are also overstressed and busy with other committees. We always appreciate when you pay us a visit, Professor Msimang. Welcome. Are there any apologies, members? On my side, I received one apology from Honorable Jele, who indicated that she is on her way. She's flying to Cape Town, so she will join us as soon as she lands in Cape Town. Are there any further apologies? None.
Good morning, Chair.
Yes, Honorable Mr. Ramano.
Yes, there's an apology from Honorable Ramlube.
Yes, she's still, yes, we received that apology last week that she has a bereavement. And when I spoke to her, she expressed her appreciation from the messages of support that she received from members. Thank you very much, members, for that show of kindness. Any other apologies? Okay. Over to you, Mr. Robertson.
Thank you, Mr. Chairperson. I'm going to share the slideshow. Can everybody see it? I hope.
Yes, we can see it.
Thank you, Mr. Chairperson. Okay, in essence...
But if you can just scroll down so that, yes.
Okay. This is the comments and responses that we received during public hearings on the Cannabis for Private Purpose Bill. As far as I know, there were 32 comments. The comments are discussed in the summary of comment, and we give responses there too. We can start at the beginning. There's a lot of general comments on the bill, which make general remarks on the bill. The first was from Professor Sperry and Mayers. They are drug experts relating to abuse, and they do make certain observations regarding the bill. First, they do say that it's correct to decriminalize cannabis for private use, since it's not appropriate to incarcerate persons that use cannabis and to waste state resources. We obviously agree with that. We also refer in paragraph 11B to the fact that the bill does not acknowledge the need, the bill do acknowledge the need to protect children and others from cannabis users. But they also propose that the bill must make other amendments to mitigate further risk in relation thereto. Must point out that it is discussed in paragraph 1.1b that the bill relates from the judgment of the Minister of Justice and Constitutional Development versus Prince, and it solely addressed the declaration of unconstitutionality of Section 4B of the Drugs Act and Section 5B of the Drugs Act, insofar as it was declared unconstitutional to cater for the rights of adult persons to use cannabis in private and to cultivate cannabis in private for his own use. I did discuss the more details, but I'm going to only deal with the relevant parts here. And Paragraph 3, it's indicated that the department is responsible for the administration of the Drugs and Drug Trafficking Act, and that the other interventions that was referred to by the honourable professors is actually outside the domain of the Department of Justice, and the aim of the bill is rather narrow to the extent that it gives effect to the Prince judgment. At the bottom of the page, I do refer to the Prevention of and Treatment of Substance Abuse Act, and that Act do provide for various interventions that can be used to address the harms associated with cannabis, and it involves various other role players, amongst others, most government departments, that's responsible for social matters. It includes the Department of Finance, Education, Health, Justice, Arts, and Culture, Sport and Recreation, as well as local government and Correctional Services and the South African Police Service. In paragraph C of the summary of comments, it is indicated that due to the fact that cannabis is legalized, there is going to be an increase in the use of cannabis. And the concern that is raised by the honourable professors is to the effect that cannabis has an impact on brain development. And according to the learned authors, this is related to persons under 25 years mostly. In paragraph D, the honourable professors provide statistics regarding the effect of cannabis on certain people and how it impacts on the current structures that is used to deal with persons with a drug problem. Our response thereto is, yes, we acknowledge that it will give rise to the use of cannabis once legalized, not only by all the adults, but also by children. And that is firstly due to the fact that it's not criminalized anymore, and a lot of people will be exposed thereto. And we also acknowledge that there is going to be an impact on the structures to deal with the harms associated with cannabis. In paragraph E, the professors refer to the fact that there should be some public awareness program to inform the public of the harms associated with cannabis, as well as the possible health implications there too. And this must be made available in an accessible format. And so we indicate, yes, public education awareness programs is obviously a harm reduction measure. But however, we cannot provide for that in the bill. The Prevention and Treatment of Substance Abuse Act already caters therefore. But also a public education awareness program is going to give rise to substantial expenditure. And obviously programs is subject to available funds. In paragraph F, there's recommendations regarding monitoring of the use of harms associated with cannabis. And these harms should be reported to increase public awareness of the harms. Some of the important monitoring mechanisms that is proposed is, amongst others, the extent of patterns of cannabis abuse or use amongst adults and adolescents, cannabis-related road traffic offences, trauma associated therewith, the effect, or let me rather say psychiatric or mental consequences that relate thereto, and also to the fact that cannabis-induced psychosis needs to be monitored. Our response thereto is that this can be catered for in the Prevention of and Treatment of Substance Abuse Act. I must point out at this stage that if one look at various overseas jurisdictions that implemented a commercial model for cannabis regulation, there is various initiatives specifically aimed at achieving the proposals of the professor in legislation that deals with that legalization. And what they do is they use the funds that is obtained from selling of cannabis and licensing and taxes thereto to address the harms of cannabis. So they legalize it, but they use the income mainly to address the harms associated therewith. That is quite similar to alcohol and tobacco in South Africa. Increase taxes to deal with the harms associated with tobacco and alcohol. The bill, as pointed out, however, do not cater for that. They also indicate that the bill may create a slippery slope regarding the enforcement thereof. And they also raise a concern that there may not be, let's call it enforcement capacities under the police to address the bill as such. Our submission in respect thereto is that yes, although the bill enforced do respect the right of privacy of adults to use cannabis, there's regulatory measures in place in the bill, mainly clauses 3, 4, 5, and 6, which imposes certain limitations on this right, and that can be used as the criteria to enforce the bill. And obviously, the reason, therefore, is to protect others against the harms associated with cannabis. In paragraph 1.2, Maureen and Noonan, the main concern is regarding the impact of cannabis in the workplace. Our response thereto is that the applicable labor law and employment contracts will regulate that. I can refer the committee, amongst others, to certain labor court decisions, amongst others, Boulder Trade Depot versus the Commission of Conciliation, Mediation, and Arbitration, where this aspect is dealt with. And obviously, it's regarded as misconduct if you use drugs in the workplace. It's treated similar to alcohol. And so the Labour Relations Act also provide for measures to deal with drug and alcohol-related problems in the workplace. In paragraph 1.3, it's mainly the comments that were provided by the South African Medical Association. They, amongst others, refer to the fact that the World Medical Association do not per se approve cannabis use for medical purposes. And the World Medical Association's opinion is to the effect that there should be some measures in place to prevent and reduce recreational cannabis use. Our response thereto is, obviously, first, there is other legislation in place that deals with that. That is the Prevention of and Treatment of Substance Abuse Act that aims to achieve those objectives. And obviously, to a large extent, the bill ensures that there is a justifiable limitation on the use of cannabis in South Africa, and is limited to the rights that is afforded in the Prince judgment to an adult. In paragraph B, they refer amongst others to the opinion of the Austrian Medical Association, who also say that personal recreational use of cannabis should be prohibited. This is acknowledged, but however, there's a constitutional judgment to the contrary that do allow for the use of recreational cannabis. In paragraph C, they refer to, amongst others, that there is scientific evidence available that indicate the harm associated with cannabis use. They also refer in paragraph D to the World Drug Report, which indicate that in South Africa between 25 and 56% of persons that received treatment had a cannabis as a primary drug problem. And they also refer to, amongst others, the social and economic position in South Africa regarding unemployment, poverty, and insufficient resources that's made available to the healthcare system to deal with the drug abuse. And our response there to is, yes, we do acknowledge this. And we do also acknowledge that the structures that aims to deal with drug abuse is under-resourced. And that the bill aims to curb some of the health and social harms problems associated with cannabis abuse through measures that restrict the use of cannabis. And again, I can refer to the other countries where cannabis has been legalized and regulated through commercial cannabis regulatory measures, which actually do provide funds to address such harms. And in paragraph G, they refer to the fact that there is ongoing stricter reform in respect of tobacco and alcohol in South Africa, in legislation that regulates that to ensure mainly public health. And I do refer to, amongst others, the Tobacco Control Act and the Liquor Act, and there's various provincial liquor legislation in place that do regulate tobacco and liquor use, as well as the availability thereof. Again, I must indicate that the bill cannot regulate this in the same manner as the tobacco and liquor legislation, due to the fact that the bill in actual effect can be regarded as an amendment to the Drug and Drug Trafficking Act to allow for recreational use of cannabis by an adult person only. And obviously, stricter reform is necessary. And if a commercial model is considered in South Africa to regulate recreational use of cannabis, which the bill do provide for in clause 1(2), similar reforms can be implemented to further restrict the use of cannabis. In paragraph 1.4, lack of consultation in respect of the bill is criticized. It was indicated previously that there was no previous, or rather there was no public consultation on the bill before Cabinet was approached for consent to introduce the bill into Parliament. And our response there to is, amongst others, that we do acknowledge the fact that it's usually preferable to make the bill available for public comment before it's finalized. But on the other hand, there is no rule or any other obligation that do specify that the department must consult on a bill before it is introduced in Parliament. In paragraph 1.5, reference is made, amongst others, to the fact that cannabis has the potential to be an economic multiplier. But on the other hand, it do restrict the ambit of the bill only to certain activities where cannabis can be used lawfully. And they also indicate to the fact that the result of the bill may be that in some instances it may still give rise to an illegal market regarding the selling of cannabis products and seedlings, which is addressed in the bill, but that is obviously the perceived consequences of the current regime as proposed by the bill. And our response there is to the effect that, again, the bill only gives effect to the limited exemption that was granted in terms of the Prince judgment. And I do refer in our responses there to what is required of the bill. And the Prince judgment, amongst others, referred to the fact that Parliament must determine an appropriate amount of cannabis for personal use. Prince judgment restrict any activities in connection with cultivation of cannabis. It is not in private and not for his or her personal consumption. It also permits the use and possession of cannabis, and that use is not per se confined to a home or a private dwelling, but it is actually specified that it is any place which can be regarded as a place of privacy. The Prince judgment prohibit the use, including the smoking of cannabis in public, or in the presence of children, or in the presence of a non-consenting adult. And in terms of the Prince judgment, the dealing in cannabis was considered, and the court remarked that dealing in cannabis is in fact a justifiable limitation on the right to privacy, which was considered in that judgment. In terms of the Prince judgment, it stipulated that the use or possession of cannabis in private, other than by an adult person for his or her personal consumption, should not be permitted in the legislation. In paragraph 1.5.2, I do discuss that the fact that dealing in cannabis and the objection thereto must be seen in the context of the right to privacy, which was considered by the Constitutional Court. And in respect of the author's comment that cannabis legalization may be used to stimulate the economy, I must again remark that the Department of Justice cannot promote such legislation that provide for commercial activities relating to cannabis, since other departments is responsible therefore. And again, I must point out that clause 1.2 of the bill do provide for the promotion of other legislation that may provide for commercialization of cannabis for recreational purposes. In paragraph 1.6, a comment was received to the effect that the bill serves.
So, Mr. Roberts, what you are saying is that this bill does not close the door to other departments, for instance, that are responsible for the commercialization, to promote legislation that will enable commercialization of the cannabis?
That is correct, Mr. Chairperson. Clause 1.2 do provide for that. It is discussed later on in the comment, but I can point out that countries amongst Uruguay, Canada, and the United States that did commercialize that actually did that in contravention of their obligations in terms of the International Drug Control Conventions. They were severely criticized in respect thereof, but no steps has been taken against them. But yes, there is an opening for other departments to ensure that legislation may be promoted to deal with, let's call it, the recreational use of cannabis and the regulation thereof through a commercialized model. I must point out at this stage that in terms of our international obligations, this cannot be actually regarded as something that can be done for profit. If other departments do implement it, it must be based on a principle that it is implemented as a harm reduction measure only. To that extent, we might not fall foul of our convention obligations, but otherwise, if it's used for pure profit and also for export, South Africa may have a problem in that regard.
But Mr. Roberts, what do you say, for instance, there is a mall next to me, mainland mall, where there are cannabis products that are being sold? Will that not be in contravention of that UN convention? And what has been the consequence since then?
Mr. Chairperson, what is allowed to be sold currently mainly relates to CBD.
CBD, yes.
Yeah, it's extractions from cannabis. CBD is not actually a drug.
Okay.
It is used for treatment. I can refer you to the Medicines Act, amongst others, where CBD was descheduled to a Schedule 4 status. So it can be used for medicinal purposes. In Schedule 6, or in the Schedules to the Medicines Act, CBD is also excluded under certain circumstances if it only contains a minimum amount of CBD. On the other hand, THC currently is regulated by the Drug and Drug Trafficking Act, and if any person sells cannabis or CBD, THC extraction, that will be in contravention with the Drugs Act as well as the law.
Thank you very much, Honorable Newbold Trachens.
Yes, Chair.
Chair, Mr. Robertson, can you just explain again, because some shopping centers obviously sell these things and some nurseries, where they sell plants and stuff, also sell these products. So how is that then allowed? Some is allowed and some are not allowed. Can you just explain that again, please?
Thank you. Okay, first, if anything contains THC, like let's say raw cannabis, that can be regarded as a psychotropic substance, that is prohibited. Currently, in terms of the Drugs and Drug Trafficking Act, as well as the Medicines Act, and only limited exemption is that provided for in the Prince judgment, namely for private use, and it must be in private, and if you cultivate cannabis, it must be cultivated in private for personal use. what is most probably be sold currently is products that contains CBD. And CBD is not a psychotropic substance. It's mainly used for medicinal purposes. And I did indicate that CBD that exceeds a certain quantity, or rather a percentage, is currently regulated in terms of Schedule 4 of the Medicines Act. That means that a doctor must prescribe it. But there is also certain exclusions where CBD is below the prescribed percentage, which do allow for these products to be sold. There's other legislation that comes into play regarding the selling of products containing CBD. I can refer, amongst others, to the Foodstuffs Act that is also administered by the Department of Health, which do impose certain obligations and restrictions on the selling of certain products. If CBD that contain, as prescribed in Schedule 4 of the Medicines Act is sold, obviously, it must be prescribed by a medical practitioner in terms of the Medicines Act. But on the lower scale, where it does not exceed a certain percentage, it can be sold elsewhere. It is sold in various pharmacies, and yes, it is sold outside pharmacies. But to that extent, the products that are sold there does not firstly contain CBD, and it is not, it doesn't contain CBD that is actually regulated in Schedule 4 of the Medicines Act. So that is my explanation regarding the selling of products. On the other hand, if any product that is sold contains THC, it's an offense. Currently, in terms of the Medicines Act, the Drugs Act, and the bill will also criminalize that. Thank you.
Then, Mr. Roberts, how does this bill assist the Minister of Agriculture and Land Reform? Because he wants to give licenses for cultivation. So one of the requests was that that part should be taken away from the Drug and Trafficking Act. Now, how does this bill, if passed, assist her?
Mr. Chairperson, yes, it's correct. Currently, if you look at the schedules to the Drug and Drug Trafficking Act, yes, it prohibits dagga, which is any part of a plant, and it includes hemp. If one look at the bill, one will see in the definitions that hemp is excluded from cannabis regulation in terms of the bill, and there's also amendments to the Drug and Drug Trafficking Act in the schedule to the bill, which remove cannabis per se from the Drug and Drug Trafficking Act. So what the bill does is it removes the restriction in terms of the Drugs and Drug Trafficking Act, firstly. Secondly, it do provide in the bill that hemp is actually excluded as cannabis for purposes of the bill, and that is also the prohibitions that do apply there too. But there are certain restrictions on that. Firstly, legislation must be promoted by the department in this respect. I do discuss it later on. And if one look at all other countries, there is specific legislation in place that regulates the cultivation of hemp, as well as the subsequent processing thereof. In terms of the bill, obviously hemp is excluded from cannabis. It's treated differently if it's cultivated in terms of legislation or other regulatory measure that is promoted by other department. And in terms of that other legislation, hemp must, amongst others, the hemp that can be cultivated in terms of such other legislation must place a limit of THC that plant contain. So the bill do provide for the exclusion of hemp so that it can be cultivated as an agricultural product. But again, it's subject to other legislation or regulatory measure that must be promoted to regulate it. So it's excluded, but it's subject to legislation that must be promoted.
You can proceed.
Thank you, Mr. Chairperson. Dealing with paragraph 1.6, there is a comment that the bill curbs medicinal use of cannabis and it infringes on cultural practices. I do refer to the fact that I do refer to the Medicines Act that regulates currently medicinal use of cannabis. The bill can obviously not regulate medicinal use of cannabis. It's not within the domain of the Department of Justice to do that. The Department of Health or the Minister of Health is the responsible person that must do it. I also do refer that the Medicines Act recently rescheduled cannabis from a Schedule 7 substance to a Schedule 6 substance, which have the effect that it can be used for medicinal purposes. And I also further refer to the fact that in terms of clause 1.2 of the bill, provision is made that the bill do not apply to a person who is permitted or authorized in terms of other legislation to deal with cannabis. And if there is a problem with cultural practices involving cannabis, other appropriate legislation must deal with that. I will discuss it later in more detail. Where I do refer to the medicinal use of cannabis by traditional healers. So let's wait till I get to that part. Thank you. In paragraph 1.7, reference is made to the fact that the bill follow a punitive approach to cannabis use. And according to the commentator, this is inconsistent with legislation that regulate alcohol. And for that, to that extent, probably also to tobacco. And there's also a remark that the bill in its current form may have a problem insofar as it comes to enforcement regarding enforcement by the South African Police Service, and the remark is made that
where to cut. So while I was climbing the tree, the cat climbed the tree next to me.
Mr. Cohen, can you mute yourself?
Yes, I'm here.
Can you mute yourself? Please proceed.
Thank you, Mr. Chairperson. Our response there too is that yes, we agree that criminalization of small quantities of drugs for personal use is not an appropriate measure to deal with drug abuse. There is reform currently under the way to the Drugs Act, which do give effect to South Africa's policy on drug abuse, which do further cater for this. the criminalization approach that the author referred to is that provided for in clauses 3, 4, 5, and 6 of the bill. And the offences there is to protect others against harm associated with cannabis use. Many other countries, even if they use a commercialized approach to cannabis regulation, do have certain measures in place that is similar to what is proposed in the bill to protect others against harm. And I do refer to some overseas legislation. Various others were considered, and that's amongst others the Canadian Cannabis Act, the Uruguayan law, Australian Capital Territories that decriminalise small quantities of drugs for personal use, and the various states in the United States, amongst others, New York, Washington, Colorado, Illinois, California, that do deal with similar prohibitions as those that is prescribed in the bill. And furthermore, insofar as the objection regarding the bill not being similar to liquor legislation is concerned, I must point out that liquor legislation, also tobacco laws, do regulate, amongst others, liquor production and tobacco production, as well as the sale and consumption thereof. And especially in terms of legal legislation, there's a prohibition to supply liquor to a minor, except in certain circumstances where there's adult supervision and for religious purposes. And there's also a prohibition in the liquor legislation regarding the involvement of a minor in any activities regarding the production and sale of liquor. Liquor consumption is also controlled and restricted to certain places. And there's a criminalization on the manufacturing of liquor and the selling of liquor products without a license.
No one is going to tell me what to do at what time.
The only exception being that one can probably brew beer for personal consumption. That is an exemption that was granted. Again, the comments regarding prior consultation is criticized by Western Cape government. I already dealt with this aspect. In paragraph 1.9, there's a remark that the bill, through regulation of the private use and quantity restrictions, actually do impact on the medicinal use of cannabis. And I already explained that the Medicines Act do regulate that, and that medicinal cannabis can be prescribed in terms of the Medicines Act. But regarding this objection, I will point out later that in certain circumstances, we may need to provide for exemption to further regulate the medicinal use of cannabis where a person cultivates it at home. And we can probably consider amendment in the bill to facilitate this. In paragraph 1.10, it's remarked that the bill must provide for scientific and academic research and studies relating to cannabis. I already explained the ambit of the bill, and it's my submission that other legislation must provide for research and studies and to further regulate cannabis for scientific purposes. This cannot be accommodated in the bill. In paragraph 1.11, it's mainly the positive aspects of the bill that's recognized by the commentator. We note that. In paragraph 1.12, it's remarked that it's not clear whether sales was conducted. Together with the documents that were submitted to the committee, the sales certificate were also submitted, which is clearly indicated that prior sales were conducted in this regard. The Western Cape remarked or makes certain remarks regarding the bill vis-a-vis other legislation. The first being that would child protection social worker conduct a cannabis investigation to determine whether a caregiver or guardian uses cannabis and whether they comply with the law or is offending. So I submission that other legislation already regulates this, amongst others the Children's Act, to determine whether a child is in need of care and protection. It's remarked that the bill impact on Rastafarian families, and incorrectly the author of referred to the fact that in terms of the bill, children in those families must be removed due to the fact that they are exposed to the use of cannabis. I must point out that the bill do not cater for Rastafarian families. They're currently subject to the regulation of the bill. As discussed later on, I do indicate that religious exemption may be considered in respect of Rastafarians. And that's discussed in paragraph 124. I will discuss it in more detail at that paragraph. They do also refer to prenatal exposure of a child and the effect thereof of the child, or rather the effect of cannabis on the child. My submission is that there may be, not is, there may be certain adverse consequences if a child is exposed during its development to cannabis. I also then referred to, amongst others, to tobacco, alcohol legislation that also do not specifically provide for this. My submission in respect of this concern is that public education awareness programs are probably the more appropriate mechanisms to address this issue. I think that is also used in respect of alcohol and tobacco. In paragraph 1.13d, the request is made that the bill should be accompanied by public awareness campaigns to inform the public on the harms of cannabis. And our response thereto is that the Prevention of and Treatment of Substance Abuse Act already caters therefore, and it can be done in terms of that legislation. In 1.14, there's objection against the drafting practice in the bill, in that on top of second page, there is explanatory note indicating that underlined text is insertions and text in brackets in bold is omissions. According to the author, this is not drafting practice, since the bill is a primary piece of legislation, not amendment act like the Additional Matters Amendment Act. My response thereto is that in the schedules to the bill, Amongst others, the Drug and Drug Trafficking Act and the National Road Traffic Act is amended. And the explanatory notes on page 2 relates to those amendments. Previously, in most primary legislation, even if there were amendments to other legislation, such a note were not necessary. But according to new drafting practices and the Bill's office, that is now a requirement. So it's a change in drafting practices. Paragraph 1.15, it's indicated that the bill is silent on the medicinal use of cannabis insofar as it relates to children under the age of 18 years. And the question is asked whether this was considered, and a request is made that amendment must be made in this regard. Our submission thereto is that the Medicines Act deals with medicinal administration of cannabis, and that was already discussed. And obviously, the bill cannot deal with aspects that is dealt with in the Medicines Act. In paragraph 1.16, the question is again raised whether hemp is excluded from the application of the bill. That is already discussed previously. I'm not going to discuss it again. But the general effect is that hemp is excluded from regulation in the bill if other legislation is promoted to regulate its cultivation. Otherwise, if there is no other legislation in place, hemp will, for all practical purposes, be regarded as cannabis for purposes of the bill and subject to the limitations as provided for in the bill. In 1.17, there is a request that cannabis should be regarded as an agricultural crop, and that it must be subject to regulation by the Department of Agriculture. I do think I did explain that previously. Insofar as it relates to cannabis as an agricultural crop, firstly, cannabis with high THC is strictly regulated in terms of the bill and the Medicines Act, and it can only be regarded as an agricultural crop probably if other legislation is regulated that regulates commercialization in respect thereof. In paragraph 1.18, reference is made that the Medicines Act and the Traditional Health Practitioners Act excludes cannabis from the ambit of medicinal use. I already explained that currently in terms of the Medicines Act, due to the rescheduling thereof, cannabis can be used for medicinal purposes. Insofar as it relates to the use of cannabis as traditional medicine, my submission is that it must be catered for in the Traditional Health Practitioners Act. The bill cannot deal with this aspect since it falls within the ambit of other department. In paragraph 1.19, the practical implementation of the bill is questioned. I think that was raised beforehand. Our submission or response in consequence thereof is that the bill is in line with foreign legislation that regulate cultivation and use of cannabis for personal use. There is a comment in paragraph 1.20 that the bill is unreasonable, unjustifiable limitation of a person's right that resulted from the Prince judgment and is contrary to the spirit of the Prince judgment. I already discussed this to the extent that in terms of the Prince judgment, the only exception or exemption to the current criminalization is that for personal use and cultivation for personal use only. Kusatu welcomes the bill but raised concerns to the extent that it does not deal with cannabis regulation in an industrial context. And they also raise a concern that some of the clauses of the bill may be harmful, unworkable, discriminatory, and contrary to the spirit of the Prince judgment. I think that was discussed already. First, to the extent that the bill gives effect to the narrow exemption in the Prince judgment. We do remove restrictions on the cultivation of hemp. And regarding a concern that is raised over and over throughout the comments is that commercialization of cannabis for commercial use was never considered when the bill was drafted. In the distribution of the documents, there is an Annexure A, and it is actually due set out the models of cannabis regulation that were considered, and one of them were, amongst others, the regulation of cannabis through a commercialized model. It must be pointed out that the department cannot promote such legislation. It's in the ambit of other departments, and clause 1(2) of the bill do provide for the promotion of other legislation that may deal with commercialization of cannabis. In terms of Annexure B, what was considered were, amongst others, decriminalization. That means that a contravention attracts a civil penalty, something that is not readily provided for in the Criminal Procedure Act. We did consider commercialization, and the problem, or rather the restriction thereto, were also pointed out, namely that we may not comply with the international drug conventions. In the document, there's also a discussion of the basis that can be used to justify our deviation from our obligations. That's in relation to constitutional rights that needs to be protected. That argument was also used by Canada and other countries that legalize cannabis for recreational use. In paragraph 122, again, there's various criticisms against the bill regarding a lack of consultation, and also that it may impact on certain rights of other people, amongst others, indigenous customs. And I think this was already discussed to a large extent, so I will not go into detail with the comment. In paragraph 1.23, a remark is made that the bill is not aligned with the drug master plan, which recognizes inappropriate of criminalization and proposes alternative measures to deal with drug-related issues. Previously, it was pointed out, yes, in respect of drug abuse, it can be handled through other measures than criminalization. But currently, the bill aims to regulate private use of cannabis, and criminalization is necessary to ensure compliance with the regulatory measures. And that is, amongst others, to protect others against the harms of cannabis. And one of the main aspects that is criminalized in the context of the bill is that the measures aims to ensure that there is no large-scale dealing in cannabis, and it also mainly protect children against harms associated therewith. Paragraph 1.24. Remark is amongst others made that the bill doesn't comply with the Prince's judgment, and they indicate that if it's passed in law, it will be challenged. I already discussed the scope of the bill, so I will not discuss this further in detail. But the important thing that is raised is that relating to Rastafarian communities as well as other indigenous communities who do not view cannabis as a psychoactive substance. And they do refer to the fact that cannabis is used by the Rastafarian community at cultural gatherings or celebrations. And they also remark that the bill do discriminate against Rastafarians and other indigenous communities. And they do propose a self-regulatory framework in respect of Rastafarians. In this regard, I must refer the committee to the judgment Prince versus President of the Royal Society of the Cape of Good Hope. Although it's indicated as the Prince 1 judgment, it's actually referred to as the Prince 2 judgment in other judgments. And this specific aspects would challenge, amongst others, that the prohibition of cannabis abuse impacts on religious and cultural rights. And in that case, it was a split judgment. But all the judges actually did accept that, yes, the criminalization in terms of the Drugs and Drug Trafficking Act and the Medicines Act at that time do impact on the freedom of religion and the practice of religion, and that it is important rights in a society such as South Africa. But three of the judges come to the conclusion that the limitation was justifiable on the basis that the Drugs Act and the Medicines Act aims to give effect to our international obligations and the war against drugs. And that judges came to the conclusion that exemption will adversely affect law enforcement and that it cannot be practically be enforced. However, three other judges, namely Judge Nkobo, Sachs and Mokgoro, however, do point out that exemption may be provided for in that legislation to cater for the use and possession of cannabis by Rastafarians. Our submission is that since it has already been recognized previously, we may probably, on the basis of the Prince 1 judgment, consider a religious exemption. Must refer the committee to, amongst others, judgments in the United States where this was also recognized. We can probably consider this in the finalization of the bill. Jamaica do provide for religious exemption in respect of Rastafarians. So that is an indication that other countries already do give effect to such a suggestion. Okay, then in paragraph 125, the Rastafarian National Council indicate that the bill is unconstitutional and cannabis should be a Schedule 0 substance in terms of the Medicines Act. And again, I can only refer to the Prince judgment and indicate that the bill gives effect to the Prince judgment. And that we cannot amend the Medicines Act, and that cannabis should in any case not be regarded as a Schedule 0 substance in terms of the Medicines Act, due to the fact that it is a psychotropic drug. 1.26, I think it's to a large extent already discussed, and since it deals with the current medicinal use of cannabis, as well as the fact that according to the author, there's no real harms associated with cannabis use. In paragraph 1.26b, concern is raised regarding the policing of the Act and the impact thereof on the right of privacy, and that it may allow police to actually search persons without clearly defined grounds. The response thereto is that criminal investigations is regulated in terms of the Criminal Procedure Act, mainly Section 21 of the CPA, and which required mainly a warrant before a search can be conducted. And the warrant will only be issued if there's reasonable grounds for believing that article is concerned in an offence. In paragraph 1.27, the mark is made that the bill continues to adopt a prohibitionary approach to drug use, that it is probably contrary to the drug policy, and they do refer to the inappropriateness of criminal sanction for drug abuse, and reference is made to the fact that the bill must be or should have been finalized in conjunction with other departments. Our response thereto is already indicated beforehand. Yes, we do recognize insofar as it relates to drug abuse that prohibition or criminalization is probably not the correct approach. The offences contemplated in the bill aims to address dealing in cannabis and protect others against the harms of cannabis. And I also indicate that if those prohibitions is not in place in terms of the bill, it will be really difficult to enforce or regulate cannabis that has been legalized. In paragraph 1.28, reference is made to the State of the Nation address of 13 February 2020, where it was indicated that South Africa is going to build an hemp industry in line with global trends. And again, it's remarked that the bill did not provide for this. Other legislation needs to be promoted to give effect to what was stated in the State of the Nation address, and wider consultation, involvement of other portfolio committees, or rather, other portfolio committees should be involved in the bill, and wider consultation should have been done on the bill. Again, our response there too is that bill doesn't give effect to industrialization of cannabis. It, however, do remove hemp from the Prohibition and the Drug and Drug Trafficking Act, and do provide for the legal cultivation of hemp if other legislation is promoted. The bill cannot do that. Other departments must do it, and clause 1.2 of the bill do regulate this aspect. Schindler's at paragraph 1.23, amongst others, do refer to the fact that our obligations in terms of the international drug control regime is subject to our constitutional dispensation. And that in terms of our obligations, such rather drugs need not be regulated through a criminal justice process, amongst others which prescribe harsh penalties and according to them is contrary to the judgment and the right to privacy. And our response thereto is, yes, we acknowledge that our obligations under the international drug control regime subject to the Constitution, but that the bill only give effect to the narrow exemption in the Prince judgment, which was granted on constitutional grounds, namely private use by adult of cannabis. I already did explain that Annex B do provide information regarding other constitutional rights that may be relevant and which can be considered if commercialization of cannabis becomes a policy of government. And in terms of paragraph 126B, it's remarked that the Prince judgment already regarded criminalization as disproportionate to harms associated with personal use of cannabis. And it's remarked that the provisions of the bill, which criminalize conduct relating to personal use, is therefore not a justifiable limitation in terms of section 36 of the Constitution on some protected rights. And our response thereto is that the objection to the bill on the basis of the Prince judgment regarding criminalization that is considered not disproportionate to harms associated with personal use and consumption of cannabis must be strictly interpreted in the context of personal use only. That is the exemption granted by the Prince judgment. And obviously, if no restrictions are placed regarding cultivation of cannabis and associated activities, or restrict that to a private place, it will be extremely difficult to enforce the bill. And I already indicated previously that other countries have certain similar measures in place and to enforce the regulation of cannabis. Paragraph 129C, it's correctly remarked that the Medicines and Related Substances Act is currently the only other applicable legislation that authorizes commercial activities in respect of cannabis, and that other legislation must be promoted to deal with commercialization in terms of section 1.2. And our response thereto is, yes, it's correct that the Medicines and Related Substances Act do provide for medicinal cultivation of cannabis, and that other legislation is required to deal with the commercialization of cannabis. That
on that note, Mr. Robertson,
commercialization may contribute substantially to the
Mr. Robertson, Mr. Robertson,
create jobs, and it will implement
Mr. Robertson,
or facilitate the implementation of other measures that can be used to address the harms of cannabis.
Mr. Robertson.
And we do recognize that commercialization of cannabis for recreational purposes can contribute substantially to the economy. But similar to
Robertson.
alcohol and tobacco, there will also be certain resultant harms
Mr. Robertson.
from
Mr. Robertson.
legalization through commercialization. And
Mr. Robertson.
can I continue?
No. I was just saying that.
Paragraph 131.
Mr. Robertson, can you hear me?
There is again a reference, or the commentator.
Sorry, Chair.
Yes, can you contact Mr. Robertson?
Yes, Chair. I've tried to mute him. I think he might be hearing us now, but when I've muted him myself so that he can take note that you are speaking.
Yes, please communicate with him that we take a break, a 15 minutes break to absorb everything that he has said. Let's come back at 11. It's a tea break.
Thank you.
Noted, Chair.
Noted, thanks.
Give thanks. Noted. Rastafari. Noted. Thanks, Chair.
extremely high amount of THC. In respect of the definition of cannabis plant, there's a remark that the idea of defining each part of the cannabis plant and having a different regulation for each is outrageous. How is the South African Police Service going to enforce this? And I do refer to the fact that it's mainly two classes of cannabis plants that is provided for in the definition, namely immature cannabis plants, that is non-flowering cannabis plants, and flowering cannabis plants. And that is also very relevant to the cannabis plant equivalent provision. I must indicate that a flowering cannabis plant is actually a cannabis plant that contains a fruit that is usually smoked or used. Immature cannabis plant that doesn't have the fruits. In paragraph 2.4.b, and the question is raised mainly to how the bill deals with hemp vis-a-vis cannabis. I already discussed this in detail previously, and it is indicated that hemp is excluded from the limitations of the bill if cultivated under other legislation that authorize its cultivation. It is remarked that to separate the plant genus into respective uses for purpose of prohibition and criminalization is unconstitutional. And our submission in this regard is that it is necessary and we need to regulate it as such to deal with personal use. Paragraph D, remarked that the definition of cannabis plant that attempts to exclude hemp is considered impractical due to the fact to differentiate between cannabis and hemp for most part of the growth cycle. Our submission is that the growth cycle of hemp and cannabis is exactly the same. It usually starts with germination. After that, there's a vegetative state, then pre-flowering and flowering. And obviously, after that, is seed development. Paragraph 2.5 deals with the definition of a child. And I must refer to the fact that the professors that previously did deal with harms associated with cannabis did refer to the fact that cannabis may have a significant impact on brain development on adolescents, that's persons under the age of 25 years. And in our response, we do refer to the foreign position, and that is in Canada. The Cannabis Act requires 18 years or older. That is the allowable age limit for a person to use and possess cannabis. Under 18 years is excluded. So they are the protected group in terms of that legislation. Similar to provincial legislation, there is an age limit of 19 years, which is slightly higher. So everybody under 19 years is a protected age group in terms of their legislation. In the United States, in most of the legislation, if not all, legal cannabis use is only extended to a person of 21 years or older. Australian Capital Territories actually legalize the use of cannabis for persons 18 years or older. Uruguay similarly required a person to be 18 years or older to use cannabis. In applicable South African legislation, the Liquor Act, amongst others, provides for 18 years for the age limit to legally use alcohol or liquor. And there was an amendment proposed that this age limit be increased to 21 years, but I do not think that bill has been promoted. And also in terms of our tobacco product control legislation, the requirement for legal use or acquiring of tobacco is 18 years or older. Regarding the definition of considerations that is discussed in paragraph 2.6, and a remark is made that considerations should be restricted to compensation involving money. And our submission is no, we cannot do that, since consideration in the context of dealing my benefits that paragraph 2.7 deals with the definition of deal-in, and it's just a remark that is made that
Mr. Robertson, can you repeat your last sentence about consideration with regards to dealing? You got cut. Mr. Robertson?
Mr. Chairperson?
Yes,
Mr. Chairperson?
can you hear you? Mr. Ntwenjeni, can you contact Mr. Robertson?
On it, Chair.
So yeah.
Mr. Robertson, we can hear you now. The chairperson was addressing you.
Mr. Chairperson, can you hear me now?
Yes, I can hear you now. I was saying that, can you repeat your last paragraph when we are dealing with consideration and dealing?
Okay. There was a proposal that the definition of considerations should be restricted to compensation involving money only. Our response thereto is that the definition of consideration is very relevant to dealing in, and it, in some instances, may involve other benefits in exchange for cannabis. Amongst others, obviously, I can provide a house to a person in exchange for 10,000 kilograms of cannabis. Regarding the definition and deal-in, the remark is that this is still rooted in understanding that the cannabis industry is filled with drug lords. We can only take note thereof, but our submission is that the criminalization of dealing in cannabis is necessary to enforce the bill and the limited exemption provided for in the Prince judgment. Paragraph 2.8, a remark is made in respect of the definition of dried cannabis, and according to the author, it's remarked that this doesn't make sense, as the drying process begins the minute after the flower and leaves have been separated from the plant. It's acknowledged that it's correct. It starts then. But however, if you look at other legislation in other countries, they do deal with this dried cannabis equivalent, and the definition is also based thereon. And our submission is that whether cannabis has been dried, it calls for objective evaluation, and that may involve, amongst others, the fact that cannabis can be smoked. Obviously, you cannot smoke wet cannabis. And furthermore, whether it's dried can also be indicated, amongst others, through the fact that it may be crumbled by means of a person through his fingers or rolled in his palm of his hand. Definition of fresh cannabis. The comment that was made in this regard is what part of the cannabis plant is referred to here. And they do indicate that the leaves of a cannabis plant contains significant lower THC than the flowers of cannabis plant. And our explanation relates mainly to clarification of the definition. And we do say that fresh cannabis is basically the part of the plant is defined in the definition of cannabis, namely flowering or fruiting tops and leaves of a cannabis plant that have been separated from the plant, and obviously that have not been subject to a drying process. I must indicate that the main parts of a cannabis plant that's used for recreational purposes is mainly the buds or the flowers. And in some instances, the buds and flowers is accompanied with the leaves. Obviously, some of the leaves of a cannabis plant do only have a significant amount of THC. Regarding the definition of hemp, it's again raised that hemp must not be determined on the basis of the EU or North American standards, and our response is that the bill actually left in the hands of other functionary to determine an appropriate percentage of THC. It's obviously that in South Africa's climate, we may not be able to comply with the 0.2 or 0.3 THC limit. And paragraph 210B mainly deals with the same aspect. Paragraph 2.11 deals with the definition of immature cannabis plant, and a remark is made that each strain is different, and depending on growth, it may be different. And according to the author, it's unscientific to propose blanket measurements and criteria that should be applied thereto. An immature cannabis plant, I think, is the main indicator here, is that it should not be flowering or do not have buds that can be smoked. Currently, in the definition, we do refer to a height and width limitation. It's 15 centimeters by 15 centimeters. Obviously, one can cultivate a mature cannabis plant probably close to that, or maybe just slightly exceeding that. That is flowering. For purposes of the bill, this height and width limitation is there to distinguish it from cannabis plant cultivation material, which includes seedlings, and it's probably necessary, but it can be removed. So this will be considered if we refine the bill further. Okay, in paragraph 2.12, that deals with the prescribed quantity, which mainly relates to clause 2, and the prescribed quantities is contained in schedule 3 of the bill. And the first question is asked is, what harm is prevented by criminalizing a person who cultivates or possesses more than a prescribed quantity? Now, submission is that the prescribed quantities ensure that cannabis use is restricted to private use. If there is no limitation on prescribed quantities, obviously it will facilitate dealing in cannabis. And I must refer the committee to the fact that the prescribed quantities in Schedule 3 of the bill, that is what a person may cultivate and possess for personal use, is quite liberal if compared with the limitations in foreign jurisdictions. So we may have to consider this if you revise the bill. Either most probably downward. And the second response there to relates to the question whether a person who grows cannabis other than for consuming it, whether that is covered in the prescribed quantities. Example is used, namely where a person uses it as a perimeter hatch or cultivated as for cattle fodder. And our response there too is that personal use as defined in Section 1 of the Act to specify that it's for the exclusive use of an adult person. And it's our submission that if cannabis is used for other purposes other than consumption, it will still be covered by the bill and is subject to the same limitations. It is obvious the reason, otherwise each and every person that has 10,000 cannabis plants would tell you that it's not for personal consumption, but it is for cattle food. And that is mainly also to address and restrict the availability of cannabis. In paragraph B, question is asked, what about persons who wish to self-medicate? And my submission is that we should probably consider a suitable amendment to accommodate this aspect. But it will be subject to certain restrictions regarding the quantity that may be possessed and the amount of plants that may be cultivated. I may refer the committee, amongst others, again to the Canadian Cannabis Act. We do provide for that, and I think it's Regulation 274 that was enacted in terms of the Act. They do regulate this aspect. And a similar amendment will be proposed during the revision of the bill. And then a question is asked, why regulate the growing and possession of a plant instead of the legitimate and illegitimate uses thereof? And the person then referred to poppies that may be grown and the resultant heroin that should be criminalized. And our submission is again is that by limiting the antecedents of the offenses of dealing in cannabis, it's necessary, amongst others, to curb first the growing of cannabis in the excessive quantity. And regarding the example that was provided by Schindler's, I must refer to the fact that the growing of poppies that can be used in the manufacturing of morphine is already criminalized in terms of the Drugs and Drugs Act, Trafficking Act, and it's also criminalized or should be criminalized in terms of our international drug obligations, which specifically do deal with poppies and poppy straw. And again, the question is raised, on one basis can the South African police enter a person's private space to enforce the legislation? I already referred to the fact that this is regulated in terms of the Criminal Procedure Act, and it's not necessary to discuss it any further. According to Fields of Green, they indicate that they worked with various scientists, and those scientists actually came to the conclusion that cannabis is harmless on a physical level. And they then recommend that the use of cannabis should set their own limitations on how much should be used or what they need for their purposes. And our response thereto is, it is acknowledged that no person has today died from cannabis use or a cannabis overdose. But again, the prescribed limitations are necessary to restrict the availability of cannabis to personal use only, and to prohibit dealing in cannabis, and to protect others against resultant harm if it's not regulated. And again, I must point out and stress the fact that the quantities in the bill is above those in foreign jurisdictions in most instances. In paragraph G, reference is made to the limitation or restriction in the context of religious or cultural milieu, and I already indicated that this may be considered in the revision of the bill. The remark is made that, again, that the prescribed quantities may not be sufficient for each and every person, and that the limitations are not based on rational considerations. If we look at the harms and benefits of cannabis, and that according to the author, the right to privacy as interpreted in the Prince judgment determine that a person may set his own needs regarding the quantity of cannabis that may be cultivated or cannabis that may be possessed. And in our response, I do refer to the fact that in terms of the Prince judgment, paragraph 79, what is stipulated there is that small quantities should be legalized or decriminalized for personal consumption. Paragraph 80 again, the court refer amongst others to the small quantities in foreign jurisdictions that have been decriminalized for personal use. In paragraph 81, there's again a reference to the fact that small quantities can be decriminalized for personal use. And furthermore, although not indicated here, and it was discussed previously, is that Parliament must set the small quantity amount in terms of the Prince judgment. So the determination that needs to be made is a safe quantity for personal use, and that emanates from the Prince judgment itself. And regarding the quantities that is in the bill, we did consider most foreign legislation that legalize cannabis for personal use. And again, the quantities is quite liberal. There's remarked regarding the fact that prescribed quantities for personal use, it's in paragraph I, are inadequate for traditional healers who require cannabis in their work, and they request amendment to this aspect, in this respect. And our submission is that this must be regulated in terms of the Traditional Health Practitioners Act, and the bill must not do this. It falls within the domain of the Department of Health to promote legislation, if needed, to cater for this aspect. And obviously, also, if there's already legislation in place, it will fall within the ambit of paragraph 1, section 1(2) of the bill. And by implication, if other legislation do provide for exceeded quantities for traditional health purposes, they will be excluded from the provisions of the bill. There's a reference to the fact that Rastafarian communities, amongst others, share cannabis between themselves, and the prescribed quantities regarding the supply and receipt of cannabis as contemplated in clause 2(3) is inadequate for these purposes. This will be considered during the revision of the bill regarding a possible religious or cultural exemption. In paragraph K, the commentator indicated that if a person uses cannabis oil for health reasons, 4 cannabis plants are not sufficient to provide a year's supply of extraction. Insofar as it relates to medicinal use of cannabis and the cultivation thereof by a person for own medical use, I already indicated that this can be regulated by amendment to the bill. However, for health reasons, the bill cannot go beyond prescribed quantities that is currently catered for in the bill. In paragraph L, commentator indicated that cannabis plants must be increased significantly to 3,500 bottles to 50,000 per household. Obviously, we cannot accommodate that in this bill, since we aim to regulate the personal use and cultivation of cannabis. Paragraph 2.13 deals with the definition of a private place, and there is a request that the definition of a private place should be extended to include places used for cultural and religious purposes. This will be considered during the revision of the bill to provide for religious or cultural exemption, and we can probably accommodate that. Definition of smoke. A remark is made that the definition excludes vaporized cannabis, which does not involve definition of cannabis. And our submission is that we will consider this aspect, and we will propose an appropriate amendment to that extent, to extend the position of smoke to vaporized cannabis. Regarding definition of a trafficable quantity, it's merely a remark that the language in its prohibition form is a concern. We can only note that it's just a term that was assigned to a certain quantity of cannabis for purposes of regulation. That's all. New definitions dealt with in paragraph 2.16, and supplemental use definition is requested, and this will be considered during the revision of the bill. There is a suggestion that we should insert a definition of medical practitioner in the bill, and that must be seen against the comment that the bill must also provide for medicinal use of cannabis or use of cannabis by traditional healers. Our submission is this cannot be accommodated in terms of the bill. Reason is that Medicines Act and the Traditional Health Practitioners Act already deal with this aspect. Okay, now we are with clause 2 of the bill, with schedule 3 of the bill, and that provides for the allowable quantities that may be used and which is prescribed in schedule 3 of the bill. I must indicate that the prescribed quantities definition is also very relevant here. Obviously, since clause 2 restricts private use to certain prescribed quantities. Okay, first, the bill provides for stringent requirement to cultivate and consume cannabis in private, which, according to the author, exclude various persons who lack space to cultivate and consume cannabis in private. And it is submitted by the author that the bill will discriminate against poor by imposing de facto prohibitions on the cultivation or use of cannabis, and this may give rise to illicit markets to obtain cannabis. Our submission is that in terms of the definition of private place, it is widely defined as any place, including a house, room, shed, etc., to which the public does not have access as of right. And it is further referred to the fact that regulations contemplated in section 32B may regulate the cultivation of cannabis in a private place. And when the definition was framed, we did take into account the Prince judgment, which amongst others stipulate that a private place is not restricted to a dwelling or a private place, but it should be dealt with on the basis that it should be in a place that is considered as private. That's in paragraph 85 of the judgment. And again, I must refer to paragraph 108 of the Prince judgment, which states similarly that it's not confined to a home or a private place, but it should be a place that's at least considered private. In paragraph 3.3, concern is raised that every section in the bill is subject to every other section in the bill. And according to the author, this is unnecessary. Our submission is, however, that the phrase is subject to this act in clause 2 is required by necessary implication. And that is to indicate that the provisions that regulate the private use of cannabis is by implication restricted by and subject to other provisions of the bill. It mainly clears the bill and make it easily to understand. In paragraph 3.4, it's remarked that in terms of the definition of personal use, that cannabis consumption and possession remains criminalized in respect of children. We must refer to the LM and 3 others judgment. It was a case where the constitutionality of Section 4B of the Drug and Drug Trafficking Act was challenged on the basis that the Prince judgment excluded children from the ambit of the reading, and it was mainly challenged on the basis that it amounted to a status offense, which is not allowed either in South Africa or in other constitutional dispensations. And the effect of this judgment is to the effect that although cannabis use and possession by children cannot be criminalized, and the bill also do not aim to criminalize this. But I must refer to the fact that there's various offenses in the bill where conduct of children is criminalized, amongst others clauses 3, 6, 9, and that relates to dealing in cannabis plants or possession of cannabis plants in a public place. Section 4.1, which criminalized the possession above the prescribed quantity in a public place. Clause 4.5, which criminalized dealing in cannabis, and various other provisions. However, I must refer to the fact that we do affect certain amendments to the Child Justice Act and the schedule to the bill to ensure that certain offences of a less serious nature will be considered as a Schedule 1 offence, and the effect thereof is that a child will not be arrested unless there are certain exceptional circumstances, and also not be detained, and that such offences is subject to Schedule 1 diversion. Paragraph 3.5 actually do acknowledge the fact that the bill do provide for greater amounts of cannabis for personal use if considered in the context of legislation of other jurisdictions. In paragraph 3.6, it is remarked that the bill should consider private cannabis clubs to use, grow, and obviously also exchange cannabis between members inter se. And our response is yes. It is acknowledged that in certain jurisdictions, cannabis clubs are implemented in respect of private use of cannabis. But we did consider that, but the regulatory measures in respect thereof is quite substantial. It requires oversight, license, inspections, amongst others, ensure compliance with the strain of cannabis that may be planted, which is considered a safe for personal use, And it's our submission that it will be impractical in the South African situation to provide for cannabis clubs in relation to the private use and consumption of alcohol. Paragraph 3.7. It is indicated that the prescribed quantities in section 2.1a is insufficient, but it must be seen against the recommendations of Wonderlife, who actually propose commercialization. And our response there too is the same, that there need to be a limitation for personal quantities used. And it's very essential to enforce the limited exemption of the Prince judgment. And in paragraph 3.8, the question is asked, how were these quantities or prescribed quantities determined? And our response there too is that we did consider legislation in foreign jurisdictions, and that the prescribed quantities are substantially in line with foreign legislation. In paragraph 3.9, it's a remark that rather in paragraph 3.9, the question is asked why does clause 2.1c provides that our person may for personal use possess in private a prescribed quantities in a public place, and why does clause 2.1d provide that the adult person may for personal use possess a prescribed quantity of cannabis in a private place? So it's a different quantity regarding the places in which this or cannabis may be possessed. And our submission is that the obvious reason for this distinction is that possession of cannabis in a public place is mostly associated with dealing in cannabis, and that a lesser amount should be prescribed in respect thereof, thereby limiting the availability of cannabis and criminalizing any exuberant amount that is possessed in public. In paragraph 3.10, question is asked, why can't a person who is not in position to cultivate their own cannabis plants request another to cultivate cannabis plants on their behalf in private? And again, I must refer to the Prince judgment to actually make it quite clear that the exemption only relates to the cultivation of a cannabis plant by an adult in private for his or her own personal consumption. So that is the limited exemption that is granted. I must also indicate that some foreign jurisdictions do allow for cultivation by either person. But in the South African context, my submission is that we should not allow this. It's obvious it aims to restrict cultivation and dealing in cannabis, since any person can probably say, I possessed 4 kilogram cannabis that was cultivated on behalf of 4 other persons. In foreign jurisdictions where this is allowed, it's actually quite strictly regulated, and there's also certain limitations. And the objection is again raised. Why must there be prescribed quantities, and why criminalize persons that exceed the prescribed quantity limitation? And I'm not going to discuss this again. It's already done with previously. Paragraph C indicate that the prescribed quantities is something similar to the presumption in dealing in drugs, which was declared unconstitutional in terms of the was declared unconstitutional. And our submission is no, it's not reverse onus in this regard, but there's a real need to limit the availability of cannabis through prescribed quantities to address harm. And in paragraph D, question is raised, does the prescribed quantity limitation apply to a person who self-medicates? Currently, yes, the prescribed quantity limitation do apply to a person who self-medicates, but we will consider this during the revision of the Act to provide for appropriate exemption in this regard. Then regarding prescribed quantities, there is again asked that this be increased regarding religious and cultural activities, and this will be considered during the revision of the bill. And we cannot, however, as provided or summarized in paragraph 311B, allow unlimited amounts of cannabis or the cultivation of cannabis plants for religious purposes. That will be strictly regulated and only in respect of and restricted to religious and cultural activities. Paragraph 3.12, in respect of clause 2.2, there is a remark that no restriction should be imposed on how much adult person may consume as long as it is in a private place. My submission is there is no restriction on the quantity of cannabis that may be consumed in private in terms of the bill. However, there's a limitation on how much you can possess in a private place. Paragraph 3.13, it's remarked that there should be no restrictions sharing of cannabis or cannabis cultivation materials between adults. My submission is this cannot be accommodated in general, but in respect of a religious and cultural exemption, we may consider this, but again, I must remark this will be strictly regulated then. Important aspect that may need to be considered relates to clause 2.3, and it's remarked that the current provision is unclear since it may be interpreted as a once-off exchange and do not actually provide how many times a person may share cannabis or cannabis cultivation material with the other adult without compensation. My submission is that clause 2.3 should be interpreted as per occasion, but it will be clarified in the redrafting of the bill. Further, in respect of clause 2.3a, it is remarked that that clause allows adult persons to give and receive cannabis plant material without compensation. But it is also indicated then that the bill further criminalize the dealing in cultivation material. And according to a commentator, the Prince judgment by implication authorizes the selling and buying of cannabis seeds, and he requested the bill be amended to facilitate the trading in cannabis seeds. My submission is that, firstly, currently the only means how you can acquire cannabis plant cultivation material is to share it, or to share it with other or receive it from other adult person. Clause 1.2 do allow for option that legislation can be promoted to regulate dealing in cannabis plant cultivation material. I will only discuss this aspect in more detail when I deal with clause 3.7. Clause 4 deals, clause 3 rather, in paragraph 4 of the summary and the responses thereto, deals with the cultivation offences. The first remark is that there should not be any restriction on Rastafarians to cultivate cannabis plants. My submission is that the Drugs Act and Medicines Act has to date criminalized that, although it is recognized in terms of the Prince judgment that Rastafarians may be accommodated. It is, however, subject to certain justifiable limitations, and obviously legislation needs to be enacted, or this will need to be drafted to accommodate that. And if that is done, even if one consider the Prince 1 judgment who recognizes right, it doesn't actually allow unlimited availability of cannabis for the use for religious and cultivation purposes. So if a restriction, or rather if exemption on a religious and cultural basis is considered, it will be strictly regulated as well in respect of the quantity that may be cultivated as well as the quantity of cannabis that may be possessed. In paragraph 4.2, question is asked,
Sorry, Mr. Dupree, on that one, do you have any foreign jurisdiction for guidance?
Mr. Chairperson, I did previously indicate, firstly, that there is the Jamaican legislation that do provide religious exemption to the Rastafarian communities regarding the cultivation of cannabis plants and the possession thereof, the use thereof, and transport thereof. I did refer to the fact that there is foreign legislation. I think it started mostly in the United States. I think the first one was the Smith judgment. There was a 2006 judgment by the US Supreme Court who did provide a religious exemption in respect of drug use for religious purposes. But other than the legislation in Jamaica, there's no real legislation that I could find to regulate this aspect. Even in South African legislation, there is some exemptions that are provided on a religious basis. I think the first one is in relation to fireworks, where it can, the prohibition against the use thereof is actually exempt, is lifted for religious purposes. And there is another piece of legislation that provides for a similar exemption. So this is something that needs to be crafted afresh. I did collect most material, but if this is allowed, obviously the circumstances that under which it must take place, or under which an exemption is allowed, should be strictly regulated. Firstly, in respect of the place where it's cultivated, the harvesting thereof, the storing thereof, and the obtaining thereof and use thereof for religious purposes. If we do consider such religious or cultural exemption, it may be appropriate to consult with the various stakeholders that represented Rastafarian communities during the public hearings to formalize and finalize such an exemption. I must refer to, amongst others, the Prince 1's judgment, where it was indicated that there is certain problems regarding the regulatory structure applicable to Rastafarian communities, and that not all Rastafarians belong to a specific church or a house, etc. But this will be considered if we formalize and consider such an exemption. And if necessary, we may request the committee either to probably ask the Rastafarian community to assist in such legislation. Some of the comments relating thereto do make provision for such an exemption, or at least discuss it. We have considered it, but there is certain shortcomings in the proposals that were made. Thank you.
So, Mr. Roberts, the consultation with the Rastafarian community, are you going to make advertisement again to invite them to make a representation to the department?
Mr. Chairperson, in the past, in some legislation, even when during the consideration of the bill, certain stakeholders have been invited to assist the committee in finalizing that legislation. This can be approached on either that, or the department can do it from its side. When we consider such legislation, mainly to consult with each and every available person that may represent the Rastafarian community, and then formalize such legislation and send it out for comment and responses to them, and take the comment and responses as well as the proposed amendment to the bill to Parliament. So it's either that we can finalize an amendment from the departmental side and consult thereon, and then approach the committee. The other thing is that the committee can probably also accommodate the Rastafarian community to make additional proposals in this regard to the committee, which will then be considered by the department. So that is the two options.
Can we have a brief discussion, members, on that? Should we take a view that maybe we should give department time, especially between now and early next year, to consult with all the relevant stakeholders with respect to this exemption for religious purposes, or should we do it ourselves? Honorable Nico Drachens, followed by Honorable Breitenbach.
Thank you, Honorable Chairperson. Just a moment. Okay, thank you, Chairperson. Yeah, there were many comments or submissions with regards or in concerns by the Rastafarian community. And I think I would support that the Rastafarian community make more submissions, or there's more consultation with them. I think, you know, we can't, you know, confine them to the medical bill or the medical medicines bill, or, you know, any specific one bill. So I think there needs to be more consultation with the Rastafarian community indeed, yes.
Thank you, Honorable Breitenbach.
Sorry, struggling to unmute. Mr. Chair, I think it would be much more helpful if the department dealt with the matter than if we did. Thank you.
Okay. Can we take it that we will, after tomorrow, it's one of the points that we are making a decision on, that after tomorrow, after we have gone through the responses, we are going to give the department enough time to consult with the relevant stakeholders, primarily the Rastafarian community, so that when we come back, maybe after the State of the Nation, when we start processing the bill, then they would have done the consultations. I don't see any objection to that. Can I take it that is a decision that we are taking as the committee?
Yes, Chairperson.
Thank you very much. Thank you very much. We can proceed, Mr. Robertson.
Thank you, Mr. Chairperson. Paragraph 4.2, questions asked how were the prescribed quantities determined, and our responses, again, we look at foreign legislation, but it must be indicated. Prescribed quantities also raise the penalties. If you look at most foreign legislation, there's a large quantity, or rather a large list of quantities that is prescribed that is subject to criminalization. So in the South African context, we do not equate each and every quantity or subdivision thereof to a penalty as considered in the bill. But this may be considered if it's necessary. That will probably also make it more equitable regarding sentencing. But I will discuss some aspects that impact on such a decision later on. Okay, there's a request that the bill must specifically make provision or specify that the prohibitions does not apply to certain offences that emanates from the lawful cultivation of cannabis plants under authority of a license issued by SAPRA. Our submission is, this is noted, this is not necessary, and clause 1.2 of the bill already provides for this. Paragraph 4.4 again relates to the possible religious or cultural exemption. I'm not going to discuss it any further. And so 4.5 relates to the previous remark that I made, and that is the proposed quantities in the schedule, which are regarded as trafficable quantities and commercial quantities, be increased to allow more leeway where a person exceed the quantities. This may be considered, but in regard to the prescribed quantities, there should be a certain limitation on how much leeway one can provide before it is a trafficable quantity and also a commercial quantity. So that will be considered. Then paragraph 4.6, it's referred to the fact that if a person has cannabis in a public place or cultivated or exchanged it, the same plant could result in different offences with their own penalties, and which may arise from the same conduct. I don't think we need to worry about this. I think it's already clarified in terms of court decisions, so-called splitting of charges or duplication of conviction principle prevent multiple convictions and sentences mostly in respect of the same kind of conduct that is subject to a prescription. There's a remark that there should be no restriction on the cultivation of cannabis plants in a private place. Alternatively, that the quantities in Schedule 4 should be significantly increased to 2,000 cannabis plants per person, or 20,000 per household. And obviously this cannot be accommodated in the context of the bill. It gives effect to the Prince judgment. And even in the Prince judgment, in paragraph, I didn't indicate it, 127, the court indicated that regarding cultivation, vis-a-vis dealing in the Drug and Drug Trafficking Act, the amount of cannabis that is possessed should serve as an indicator whether it's for personal consumption or not. And obviously, unlimited cultivation of cannabis plants in a private place will facilitate dealing in cannabis and severely jeopardize the implementation and enforcement of the provisions of the bill. Paragraph 4.8, it's remarked that the prescribed quantities of cultivation of cannabis plants discriminates against large families or households, since there may be more than 5 people living in a house, for instance, and it is restricted to certain limitation per dwelling. And our response in respect thereto is that most foreign jurisdiction legislation provides for such a limitation. And it's obviously that if we allow for each and every adult in a household to possess cannabis, one may end up with a quantity of cannabis plants that is sufficient to actually deal in cannabis. So our submission is that this should not be considered. In paragraph 4.9, question is asked whether we considered the South African context, especially insofar as it relates to informal settlements regarding the provisions that limit the accessibility of cannabis plants to a child. And so our submission, we have considered it. That's the first thing. And our second remark in this regard is that there is a definite need to ensure that cannabis is not accessible to children, and that the right of a child to trump the adult person's right to cultivate cannabis for recreational purposes. From a similar look at the tobacco legislation, as well as alcohol legislation, also provides for provision that limit access of cannabis and alcohol to children. There's a remark that expression.
Honourable Mayor Druchen has a hand up.
Honourable Newt Druchen.
Thank you, Chair.
I'm not clear with regard to 4.8 and the response to 4.9, those two. The answer relates to the use in foreign jurisdictions in terms of households. Many houses in South Africa are overcrowded. And I'm not sure if in foreign jurisdictions they have overcrowded houses as we do in South Africa. So we can't really compare it to other countries. That's the one. And then 4.9, I want clarity on the South African context as it relates to human settlements. Was that considered? And then the answer said, then the answer is about children. I'm not sure if that question raised was with regard to children. I think it was with regard to the overcrowding in the South African homes, and that it should not be compared to foreign jurisdictions. So I just wanted clarity. I also wanted to ask if I'm in my private home, the quantity of cannabis that I have is obviously for one person. But now if there's more people there in the house who use cannabis, but they are not given the same quantity for each person in every home. So I'm really not clear on those 2 points there. Thank you, Chair.
Thank you, Honorable Lewis Drachens. Can you lower your hand? Thank you very much. Over to you, Mr. Robertson. Maybe you must indicate in your responses when you make reference to foreign jurisdiction, whether they are from developed countries, developing countries, or least developing countries.
Well, thank you, Mr. Chairperson. Regarding the quantities, I can, in 4.8, most legislation is obviously from developing countries. The exception being that of Uruguay, probably, but yes, it's developing countries. And regarding the amount of people that may live in a household in the South African context, it is acknowledged that it may to an extent discriminate or treat larger families on an unequal basis with smaller families. But on the other hand, one must also consider the practical implications of the availability of a large quantity of cannabis plants if we do determine a person to cannabis plant quantity restriction. Let's say in some households, there may be 8 persons living in a house, adults. And the amount of cannabis plants that may be cultivated in that regard is quite substantial. If one cultivated cannabis sativa outside, a substantial amount of cannabis may be harvested therefore. But it can be considered. The bill just gave effect to the foreign jurisdiction limitations, and we did consider this in South Africa, but our submission was that we need to restrict it per household. It can be changed, it's not cast in stone, but the consequences thereof needs to be taken into account, since the main aim of the bill is obviously first to curb dealing in cannabis. One must also remember that in some instances, cannabis is not always cultivated, among others, outdoors. I can cultivate it in, let's call it a cultivation room or a cupboard. And the period for harvesting is limited, or rather, it's far lesser than where you cultivate cannabis outdoors. You can actually harvest cannabis cultivated indoors probably after every 3 months. So the availability thereof may give rise to certain problematic aspects. But let me rather provide an alternative solution to this. I will mark it as an aspect that needs to be considered. If 4.9 relates to 4.8, I think I did explain that. As far as I can remember, one of what was actually raised by the Western Cape in that submission, I haven't got it before me currently, mainly relates to the non-availability of a cannabis plant. And in an informal settlement, it may be problematic. People live close by each other. And what measures needs to be implemented to restrict access to cannabis plants by children. And firstly, obviously, the main aim is to protect children against the harms of cannabis by making it inaccessible to them. And our response is that the right of the children to be protected against harm trumps that of an adult person to cultivate cannabis for recreational purposes. So it is discussed in that context, but if 4.9 relates to a similar situation in that discussed in 4.8, I think it is covered. But as far as I can remember, it relates to the availability of cannabis and the measures that needs to be implemented to ensure that it is inaccessible to children. Is everything answered? Honorable Nivite?
Honorable Nebo.
Thank you, Chair.
Thank you very much. Proceed, Mr. Robertson.
Thank you, Mr. Chairperson. Paragraph 4.10. It relates to, the comment relates to a phrase in clause 3.2a, which require reasonable measures to be implemented. And in 3.2b, there needs to be certain standards that need to be prescribed regarding cannabis plant cultivation. So, according to the commentator, the reference to reasonable measures is quite vague, and it is indicated that the provisions should provide for accurate standards in paragraph B regarding the cultivation of cannabis and things that must be addressed are, amongst others, the isolation of cannabis plant area that must be safe and secure, size of grow rooms, etc. And our response there too is that this may be considered if we revise the bill. Paragraph 4.11 refer to the fact that in South Africa, many people live in informal settlements. It's densely populated and do not actually have their own private space to grow or store cannabis. And it's our submission that or rather, this is already addressed in the previous discussion of paragraph 8 and paragraph 9. So it is a concern currently that not all people can implement security measures to ensure that cannabis is not available to children, if you look in the South African context. That is acknowledged. In paragraph 4.12, this is remarked that a person who do not live in a house with a private garden, he cannot cultivate cannabis plants. And reference is also made to a person who lives in a flat or a dwelling with no garden, where there's a place where children have access to a possible place for cultivation of cannabis plants. And according to the author, this actually restricts a person's ability to give effect to the act, and that in such instances, you will turn to the illegal market to get cannabis, and that is criminalized in terms of the act. And I must refer to the response that private place is defined in the law quite broadly as mainly any place to which the public doesn't have access as of right. And I'll really refer to the interpretation that was assigned to the private dwelling, but it should be any place that is considered as private. Regarding the concern that there may be instances where a person cannot cultivate his own cannabis plants, due to the fact that he lives in a formal settlement or a flat, etc. The only provision currently in the bill that may be resorted to is clause 3.2 that provides for the exchange of cannabis without remuneration. But again, I must indicate the bill is substantially based on legislation of foreign jurisdictions. And in most foreign jurisdictions, a commercial model for recreational cannabis regulation have been implemented. And the provisions in the bill, although provided for in their legislation, is something that is subsidiary to the commercial model. So in terms of foreign legislation, a person who cannot cultivate cannabis usually goes to a cannabis store, buys it, take it home and use it. The current South African situation do not allow it, and the bill cannot provide for that due to the limit, due to the extent that it only provides for private use of cannabis and private cultivation of cannabis plants. Previously, it was a remark was made that cannabis plants may be considered in this regard. In the South African context, I do not think that cannabis clubs will serve this purpose. The reasons, therefore, were already raised previously, amongst others, that there needs to be oversight, it needs to be police. Funding is required to implement such cannabis clubs, and it's unlikely that a cannabis club license will generate sufficient revenue to actually police or enforce cannabis club regulation in South Africa. Paragraph 4.13, that there should be no restriction on cannabis plants in a public place. My submission is it should be restricted to aim is to deal with the dealing in cannabis. It's remarked that clause 3, 6, and 7 do not fully consider the commercial realities when prohibiting the exchange of cannabis plants without, clauses 3, 6, and 7 does not consider the commercial realities when it prohibits the exchange of cannabis plants, cultivation material without remuneration. And again, I can only refer to foreign legislation. The advantage of the commercial model for recreational cannabis regulation do adequately deal with such aspects, but the bill cannot deal therewith, since it can only regulate cultivation use of cannabis within the ambit of the Prince judgment. Reference is made to clause 2.3 of the bill that allows for the exchange of cannabis cultivation material without remuneration, and clause 3.7 criminalize the exchange of cannabis plant cultivation material for remuneration. And the question is then asked how cannabis plant cultivation material can be obtained, since there's no other law that provides for this. And our response there is again, exchange may take place without remuneration that is provided for in the law. And I must refer to the Plant Breeders' Rights Act, and that regulates the trading and propagating material. Since clause 1.2 provides that other legislation apply in addition to the bill, the Plant Breeders Act can be used as a legislation that enables the selling and obtaining of cannabis plant cultivation material. I must, however, indicate that in terms of our international obligations, such selling or dealing in cultivation material may fall foul of certain provisions of our international obligations. And it is also stated further that obviously, since there's no outlet to obtain cannabis cultivation material, it may give rise to a illicit market, and this aspect is acknowledged. I'm not going to deal further with the comments in 415B, since it has already been discussed. Okay, then again, the question is asked in paragraph 416, what harm is prevented by criminalizing behavior where the person cultivates in excess of a prescribed quantity? Again, it's aimed to enforce the limitations to ensure that cannabis stay within the private use sphere and to limit dealing in cannabis. 417, that relates, the comment in 4.17 relates to religious cultural exemption. And this we'll not discuss in detail, but the department will consider this. Paragraph 5 of the comment and responses deals with the cannabis offences. Clause 4, read the Schedule 4 of the bill. And it's remarked that the cannabis offences in effect ensure that no commercial activities are allowed in respect of cannabis, and our response is this is obviously correct. I'm not going to deal in detail with the harms that is prevented by criminalizing an access quantity. I think that has been explained over and over. In 5.3, there's a request that there should be no restriction on cannabis for purposes of religious or cultural purposes. This will be considered in a religious exemption. In 5.4, this request to the bill must be amended, or rather this provision, to indicate clearly that persons who possess or perform any activities with cannabis on the authority of a license by SAPRA should specifically be excluded. My submission is that this is not necessary. Clause 1(2) of the bill already provides for that, and obviously where under legislation authorize something, that exemption authorization ensures that a person can be prosecuted for offence in terms of the bill. Paragraph 5.5, it's marked that there should be unrestricted possession of cannabis in a public place, and this, our response is that this cannot be accommodated. And the reason why we restrict the quantity of cannabis in a public place is mainly to curb dealing therein. Clause 4.3 relates to the storing of cannabis. And it relates to storing of cannabis in a secure place. And it's indicated that there's no clear guidance what should be considered as a secure place. This is almost similar to the previous comments in respect of the cultivation of cannabis plants. And similarly, we will consider this and see if we cannot clearly, to some extent, indicate what requirements and standards need to be prescribed by means of regulation. 5 and 7, fields of green again indicate that cannabis is, according to them, not harmful. The restrictions is actually disproportionate to the harm that is actually caused by the availability of cannabis. And again, I can only infer that dealing in cannabis cannot be accommodated in the bill. I will not discuss this aspect in further. 5 and 8 is indicated that it is irrational to require that cannabis must be concealed from public view, especially since alcohol can both be displayed and consumed in a public area. And our response is that the aim through this provision is to address dealing in cannabis. Firstly, cannot allow people to actually display cannabis to people for purposes of sale, firstly, and it may also facilitate the selling of cannabis. And the other reason is that it entices others to use cannabis, especially children. I must look at foreign legislation which do not only contain a similar provision, but they also prohibit aspects relating to cannabis accessories such as bongs or certain, let's call it stickers that display a cannabis leaf. And the reason is similar to the aims of this provision, namely not to entice others to use cannabis. So that is one of the reasons why cannabis cannot be displayed in public. 5.9 again relates to cultural or religious exemption. This will be considered. I'm not going to discuss the proposed text since there's various shortcomings. Paragraph 6 deals with smoking and consumption offences, and that's dealt with in clause 5 of the bill. It's indicated in paragraph 6.1 that the element judgment excludes children from the provisions of the bill. This has already been explained. Yes, insofar as it relates to possession of cannabis and some provisions of the bill, children is excluded, but in other instances, children are included and can commit criminal offences. I don't think that's contrary to the element judgment at all. Regarding the second-hand exposure to cannabis smoke, it is already indicated in the beginning that the two professors did indicate that second-hand smoke may have harmful effects on others. They do indicate that the offences should be increased, especially when cannabis is smoked in the presence of a child or non-consenting adult. And it is also raised whether we should not address persons under the age of 25. My submission, and for the reasons provided beforehand, I don't think we need to expand the provision to include persons of 25. Foreign legislations do provide a cut-off point of 21. And if a person uses cannabis in the presence of a child, foreign legislation do criminalize that. But in foreign legislation, this smoking prohibition is enforced through the tobacco legislation. 6.3 against relate to the South Africa social economic position, and the question is, the following question is posed, namely, that millions of South Africans live in crowded sheds. And the fairness of clause 5 need to be considered against this background. It indicates that if there's a one-room shack that is occupied by a family and there's children or adults who object to the smoking of cannabis, the person cannot smoke cannabis in that room or in the presence of the adult. My submission is that the prohibition emanates directly from the Prince judgment, which specifically did not extend the use of cannabis to that where it's used in the presence of a non-consenting adult, and it explicitly prohibits that cannabis can be used or smoked in the presence of a child. Obviously, we must again look at the definition of a private place. And there is many places that can be considered as private, where cannabis can be consumed. For instance, another friend's house, or probably somewhere in the field, etc. Again, cannabis clubs were considered in the context, and which may provide a solution, but again, the problem is that it's difficult to implement cannabis clubs in South Africa. Paragraph 6.4 relates to the use of cannabis in a cultural or religious setup. This will be considered when we deal with religious and cultural exemption. Obviously, for certain cultural and religious purposes, it will be consumed in the presence of an adult person, and it will also be used or consumed in places that is more public in nature by the persons to those provisions relate. 6.5, question is asked, how is the prohibition against the eating of cannabis in public place going to be enforced? This is also very relevant to driving under the influence of a drug. I do indicate here that an oral drug screener may be used to detect the presence of THC. Obviously, similar to driving under the influence of drugs, there's other criteria that may indicate that, amongst others, that a person, physical condition is such that he can be considered under the influence of a drug, and in such instances, the person may then obviously be subjected to a blood test. The important aspect is raised in paragraph 6.6, and that is that the prohibition regarding the consuming of cannabis may extend to food products and medicines, etc. And similar as previous indicated, this will be amended to clarify the provision, and we will provide for a limitation on what may be consumed in public and what may not be consumed in public, and that is 0.2% THC, which is the cutoff point. It's remarked that the obligation on a person to consume cannabis within their own homes is unjustifiable infringement of the right of privacy. Our submission is it emanates directly from the person's judgment. There's also a submission to the effect that clause 5.2 must be amended to provide that any person who smoked cannabis in the immediate presence of any non-consenting adult should be guilty of an offence as currently provided, unless such conduct take place in the area designated for smoking cannabis. And obviously unless it relates to a religious or a cultural ceremony. In terms of the tobacco legislation, there's a prohibition on the use of tobacco in a public place, but one may use tobacco in a specific designated place. In terms of the bill, any use of cannabis in public is prohibited, and we don't envisage, similar to tobacco, to provide for designated places where a person can use this specifically. But obviously, it is possible, amongst others, for a hotel to designate a place for smoking of cannabis. It is explained there, if it's concealed from others, the smoke doesn't hinder others, it may be considered as a private place for purposes of the bill. Again, refer to the fact that there is certain instances where it will not be, where a person cannot easily use cannabis for private purposes, amongst others, where he rents a place, or where there's children, or where the other adults does not consent. It is already discussed above that there should be a limitation to some extent to protect others against the harm of cannabis. And we cannot do away with this provision that actually prohibits that, since it also gives effect to the Prince judgment. Paragraph 6.10 deals with aspects relating to cultural or religious ceremonies. This will be considered in a redraft of the bill. There is a remark in paragraph 6.12 that the bill is inconsistent with the tobacco legislation. My submission is that it is in line with the Tobacco Products Control Act, especially section 2.1, which deal with the prohibition of smoking in a public place, area from a certain window, smoking in a motor vehicle, etc. In terms of the bill, smoking in a motor vehicle is prohibited and as an offence. Aspect that is not addressed is a specific place designated by the minister, but it relates to outdoor public places. The bill cannot accommodate that, since it is a public place, and that is prohibited in terms of the bill. Paragraph 6.12.
Mr. Roberts, just wait a bit. Members, it is unlikely, even if we wanted to finish the bill today. So I suggest that we break now to allow members to eat and to prepare for the House, and then we will proceed tomorrow to finish the bill. Is that in order, members?
Yes, Chair.
Okay, thank you.
Honorable Nivot Jachens?
Yes, just to agree with the break. Thank you, Chair. It was a lot of information today.
Yes. No, that's true. So let's meet tomorrow at 9:30, and it is likely that we will dispense with this bill quickly tomorrow. I suggest that we deal with the minutes after we have dealt with the issue of the bill. And then is it possible that we can deal also with the BRRR reports, so that we can deal with all the internal issues, so that we reserve Friday only for a briefing on the regulations, the legal practice regulations, and then we can have the day for the subcommittee on correctional services. Will that be in order?
Yeah, that's fine. Thanks.
Honorable Chairwoman Griffin has her hand up.
Honorable Neverdrachen.
Thank you, Chairperson. Yes, Chair, I'm in agreement to finish all of the internal things tomorrow after we've done with the bill. I know that there is no plenary on Friday morning, but the committee is scheduled to sit at 2:00. So I'm just wondering if it can be moved to the morning on Friday.
Yes, I think that would be updated. I think the committee program would be updated. We will meet in the morning and deal with the regulations, and then we allow the subcommittee to meet on Friday, so that we know that early next week we will just adopt the regulations so that they can. In fact, we process the regulation. I don't want to assume that we will adopt them. We deal with the report the following week, so that we can see if we agree with the regulations. They can go to the House. If we don't, then we will discuss the way forward. I think thank you very much, Honorable Velma, for raising the issue. The program will be updated accordingly. Thank you very much to all the participants, Mr. Roberts, for a grueling day. Please take the strength and take a break so that we can finish tomorrow. And to all members for your work, for your hard work, to everybody and to everybody who is watching at home. Thank you very much. The meeting is adjourned.
Thank you, Mr. Chairperson.
Thank you, everyone.
Thank you.
Thank you.
Thank you, Chair. Bye, everyone.